Welcome to EU Privacy for All, Session 68 on GDPR, Urgency Procedure, Article 61. European Parliament deleted paragraph 2, 3 and 4 of Article 61, but did not provide any major change in paragraph 1. On its side, EU Council added a reference to intended produce legal effects within the territory of a member state, and the fact that a supervisory authority shall, without delay, communicate measures taken in the frame of the urgency procedure and the reasons for adopting them to the other concerned supervisory authorities. In its final draft, Article 61 lays down that a DPA can adopt urgent measures in exceptional circumstances in order to protect the rights and freedoms of the data subjects. This will be done by way of derogation to the consistency mechanism. In such a case, adopting immediate provisional measures will be possible only if the legal effects produced are limited to the territory of the DPA and limited to a period of validity that shall not exceed 3 months. In such a case, the DPA will have to communicate this decision to other concerned DPAs, the European Data Protection Board and the Commission. Where a DPA considers that final measures need urgently to be adopted, it may also request an urgent opinion or an urgent binding decision from the EDPB. Any DPA may request an urgent opinion or an urgent binding decision from the EDPB, where a DPA has not taken an appropriate measure in order to protect the rights and freedoms of data subjects. By derogation, an urgent opinion or an urgent binding decision shall be adopted by the EDPB within 2 weeks by simple majority. Article 54(4)(d) also lays down that in exceptional circumstances, a DPA, having reasons to consider that there is an urgent need to act in order to protect the interests of the data subject, shall use Article 61. Currently, the directive does not provide any provision on the urgency procedure. What should accountable data controllers and processors get prepared for? First, knowing that the consistency mechanism can be derogated to in exceptional circumstances in which a DPA would consider there is a urgent need to act in order to protect the rights and freedoms of data subjects. In such a case, the DPA may immediately adopt provisional measures producing legal effects only on its own territory. Those measures will not exceed 3 months, and the DPA taking the measures will have to notify other concerned DPAs, the EDPB and the Commission. There is also another way to proceed for the DPA, considering that final measures need urgently to be adopted. They may request an urgent opinion or an urgent binding decision from the EDPB if giving reasons for doing so. By derogation, an urgent opinion or an urgent binding decision shall be adopted by the EDPB members within 2 weeks by simple majority instead of 2/3. A final decision should confirm the one initially adopted. So the question triggered now will be knowing whether the measures adopted in urgency, nationally or by the EDPB, will create inconsistencies on the long run or will allow a better protection of data subjects' fundamental rights.